Hello everyone, this is Lakshmi Saujanya. Under Indian Polity for various competitive exams, we get to go through various topics for our foundation. And among those things, one important topic is landmark judgments of Supreme Court. So there are a lot of landmark judgments of Supreme Court which we have to go through. And here in this video, we are going to discuss one of those landmark judgments of the Supreme Court, which is S.R. Bommai versus Union of India case of 1994. So regarding any landmark judgment, first thing that we have to remember is the year in which that particular case took place. So here in case of S.R. Bommai case, it is 1994. And then what is the subject matter of that particular case? So that is the second point that we have to know. So this particular case is regarding the emergency, right? So we'll discuss about this particular case. So what was the issue? What was the background of this particular case? And also in connection with the various articles of the constitution. So these are the things that we are getting to know in this particular video. So let's get started. So coming to the related articles of the constitution, in this particular case, before moving into the details of the case, we have to brush up some articles of the constitution. As we know, our constitution is a lengthy constitution and we have lot of articles in our constitution. But from the point of view of various competitive exams, we have to remember the content of some of the important articles. And here, in this case, these are the articles that are related to this S.R. Bommai case. First is our Article 352. So what is our Article 352? It is regarding the proclamation of emergency, right? And then coming to Article 355, it is the duty of the Union to protect states against any external aggression and internal disturbance. That means in case there is some external aggression on any of the states of our country, or if there is any internal disturbance in the within the state, it is the duty of the union to protect that particular state. And this is according to our Article 355. And coming to our Article 356, so this particular article has provisions in case of failure of constitutional machinery in states. So within the states of our country, if there is a failure of constitutional machinery, so what all provisions are to be provided? So this is mentioned in Article 356, right? And coming to Article 360, it has provisions regarding financial emergency. And then coming to this Article 355, it imposes a duty on the center to ensure that the government of every state in our country is carried on in accordance with the provisions of our constitution. As we know, within our constitution we have lot of provisions and every state has to follow these provisions, right? So whether these states are carried on with in accordance with the provisions of the constitution or not, if they are not carried in accordance with those constitutional provisions, this has to be ensured by the center. So who has a duty to ensure that every state is carried on within this constitutional provisions? It is the center. So which article imposes such a duty on the center? It is Article 355. So please do remember this point. And coming to Article 356, in case there is a failure of constitutional machinery in the state, what will happen? Center will take over the government of that particular state, right? So for example, in this case of, for example, take Andhra Pradesh. In case there is a failure of constitutional machinery in that state, what will happen? Center will take over this government of Andhra Pradesh, right? So that will be the case with any state. So in case there is a constitutional machinery failure in any state, center will take over the government of that particular state. And this particular thing is what is popularly known as our president's rule. And we have two more names for this particular thing, that is state emergency or constitutional emergency. So these are the three important terms that we have to remember. So three are one and the same. So according to Article 356, in case there is a failure of constitutional machinery in any state, center will take over the government of that state, and that is what is called as our president's rule or state emergency or constitutional emergency. So we have seen that president's rule will be imposed as per Article 356. So what would be the grounds for this proclamation of president's rule? One is mentioned in Article 356, right? And another one is mentioned in this Article 365, right? So according to Article 365, whenever a state fails to comply with any direction given from the center, as we know, center gives some directions to the states, and states have to comply with those directions of the center. In case a state fails to comply with those directions from the center, then the president, if he feels that there is such a situation in which this particular state cannot be carried on in accordance with our constitutional provisions, then he can declare this particular president's rule. So these are the important articles that we have to remember. So we are not going into the details of the approval of the proclamation of president's rule, right? So here, as an overall understanding, do remember, for the approval it must be approved by both the houses of parliament within 2 months from the date of the issue, right? So if it is issued when Lok Sabha is dissolved, or if dissolution of Lok Sabha takes place during the period of these 2 months without approving this proclamation, then this proclamation will survive until 30 days from the first sitting of Lok Sabha. So do remember this. So if approved by both the houses of parliament, this will continue for 6 months. And what is the maximum period that it can be extended? It is 3 years, right? And within these 3 years, it must get approval from the parliament every 6 months, right? So do remember, for the proclamation of president's rule or for its continuation, it can be passed by either house of parliament, and it will be only by a simple majority, right? And coming to our next thing, that is important amendments related to this particular case, right? So here, 44th Amendment Act of 1978, it introduced one new provision to put a control on the power of parliament to extend this proclamation of president's rule beyond 1 year, right? So beyond 1 year, this president's rule can be extended by 6 months at a time, only when there are some certain conditions which are fulfilled. One is, our election commission of India must certify that general elections to that particular state's legislative assembly cannot be held on account of difficulties. And second thing is, national emergency should be operational in the whole of India or whole or any part of the state. In these two cases, president's rule beyond 1 year, it can be extended by 6 months at a time only. And coming to these amendment of 38th Amendment Act of 1975, it made that satisfaction of presidents in invoking this Article 356 is final, and this cannot be challenged in any court on any ground, right? So according to 38th Amendment Act of 1975, do remember that whatever proclamation is done by the president according to Article 356, president's satisfaction is final. So no judicial review, and it cannot be challenged in any court on any ground. But this particular provision, it was deleted by the 44th Amendment Act of 1978. What does this mean? This means that the satisfaction of president is, it is not beyond judicial review, right? And then coming to our case, that is SR Bommai case. So we'll look at this particular case now. So till now we had a background of the constitutional provisions which are related to this particular case, and now let's look at the details of this particular case. So SR Bommai, who was this person? He was the Chief Minister of Karnataka between August 13, 1988 and April 21, 1989. So he was representing the Janata Dal government. So do remember the years and also the government. So what happened? What was the issue here? So his government was dismissed on April 21st, 1989. So this was done under Article 356 of the Constitution. So we have already discussed what is Article 356. Right. So under this Article 356 of the Constitution, the government of Mr. S.R. Bommai was dismissed in 1989, and then President's rule was imposed. So what were the grounds for declaration of this President's rule at that particular time? It was that that particular incumbent government does not have a majority. The reason that was cited that SR Bommai's government did not have a majority because there were a lot of defections of large number of MLAs. So this concept of defection is also important for us from Indian polity point of view, right? So at that time, since there were a lot of defections of MLAs, the government did not have necessary majority. This was the reason that was cited to proclaim this president's rule under Article 356. Right. Then what Mr. Bommai did was he has presented lot of letters to the then governor to, and he has also requested him to give some opportunity to prove his party's majority in the assembly. Right. So reason that was cited was he did not have the necessary majority. So what he has done is he requested the then governor to give him a chance to prove his majority in the assembly. Right. But that particular governor at that time, he refused to give him an opportunity. So what Mr. Bommai did, he went to the court against this decision of the governor to dismiss his government and impose president's rule. So what he has done is he approached this high court first, right? But the then high court dismissed his writ petition. Then he sought remedy from the Supreme Court. Now what did the Supreme Court do? So what were the issue before the Supreme Court regarding this SR Bommai versus Union of India case of 1994? Right. So first thing is, whatever proclamation is issued by the president under Article 356, is it subject to judicial review? Right. And what is the scope of judicial review in this case? And also, as we have discussed, government cannot be carried on in accordance with the provisions of the Constitution. This is what was mentioned in Article 356. Right. So what is the meaning of this particular expression? These were the questions before the Supreme Court in this particular case. So finally, Supreme Court has come up with a judgment or a verdict. So what was the verdict in SR Bommai case? Supreme Court held that so the satisfaction of the president in issuing this proclamation under Article 356, it was open to judicial review. Right. So the court can review this particular satisfaction of the president in issuing a proclamation under Article 356. So judicial review is one more important concept that we have to go through from Indian polity point of view. Defection and also judicial review. So I'm not going into the details of this, and also you have to go through the differences between national emergency and also president's rule. So these are various subtopics that we have, so which are lengthy topics. So in this particular video, we are going to stick to this particular case. So do go through these basics also for more information. Right. So as we know, satisfaction of president, it was made open to judicial review. And whatever the satisfaction of president is present, that must be based on relevant material or report. Right. So just based on the governor's opinion, president cannot proclaim this. Right. So it must be based on some relevant material or reports. And if it was found that the reasons are malified, then whatever action of the president was there regarding this proclamation of president's rule, this particular action can be struck down by the court. Right. And then who has to prove that there is a relevant material? So whatever president's rule was imposed, to prove that there is a relevant material that exists to justify this, who has the burden to prove it? It is the center. Center has the burden to prove this particular thing. Right. And court cannot go into the correctness of the material. It can just see whether it is relevant to the action or not. Right. And If the court holds that president's proclamation is unconstitutional or invalid, what will happen then? Court has the power to restore that particular dismissed state government. So it can revive that particular state legislative assembly if it was suspended or dissolved. So these are the things that you have to remember, right? And coming to this SR Bommai case, right? So what was finally held by the Supreme Court? Supreme Court upheld the validity of this proclamation, right? So this was done on the basis of our basic structure of the constitution. So basic structure of constitution is one more thing that we have to go through, right? Basic structure of the constitution is one of the important concepts of Indian polity, right? So these are the things that we have to remember. Secularism, it is one of the basic features of the constitution. So this was cited and said that Supreme Court has upheld the validity of this proclamation in this case of SR Bommai. So this is about our SR Bommai case, right? So prior to SR Bommai case, basic structure test was applied by the Supreme Court in judging the validity of constitutional amendments, right? But in this case, satisfaction of president and passing a presidential order, this was also tested through this basic structure doctrine, right? So this was one more thing that you have to remember. So, in this particular SR Bommai case, Supreme Court upheld the validity of the proclamation, and the ground is that secularism is a basic feature of the constitution, right? And as we know, secularism, it was not present in the preamble of our original constitution. So preamble is one more important concept that you have to go through, and secularism was a term that was added by the 42nd Constitutional Amendment Act. So this is one more point that you have to remember, right? So that's all for this video. So hope you are clear with the SR Bommai case and the basics. Thank you so much for watching this video.